Yes.
Well, I'm paying for listing this with appeal, madam. This with appeal, madam. Can you put it on Monday, madam?
Monday, Tuesday? Tuesday is hearing day.
Hearing. Monday. That's with him.
Actually, waiting for listing, Lordship. If I leave on 1/12/2022.
Wednesday.
Wait, please, Lordship. Which is, with the consent of other side, I beg to mention item to a two, Lordship.
Two, yeah.
Yes. The reading council, Mr. R.S. Chaudhary, having some personal difficulties today.
Okay,
Can
right.
it be on after 11? 11.
Okay, I'm for the respondent number 9 and 10.
In the new year?
Lordship, can it be on the month of December, Lordship?
No,
Stay was operating, Lordship, that is why.
in the PIL?
Yes, Lordship. We have already filed a stay vacating application also, Lordship. They were supposed to file their objection, Lordship. Can it be on the month of December? Any date 16, 17, 18, Lordship?
Right. Adjournment prayer has been made on behalf of Mr.
R.S. Chaudhary.
R.S. Chaudhary. Miss R.S. Chaudhary, the council for petition. The same not being objected, this is the matter. You it is.
Obliged.
Should I beg to mention item number 10, should I got some personal difficulty today? If it can be in the next week, should I got that?
Okay, right.
My friend appears for
Okay, right. On the prayer for adjournment made by Mr. R.K. Please, council for the appellant NIA. How it is not objected to by Mr. P. Prasad. This is the matter. When do you want?
it can be in the next week. It's convenient for them.
Next week. Yeah, after the vacation.
First week of
First week of January. 19th. My lord, it has come up for orders today, but it should come up for hearing, madam.
Okay,
Hearing.
why is it, what is the issue? The minimum sentence has not been given or what?
That's what they have challenged.
The minimum sentence has not been given, is it?
Lordship, the sentence is
Inadequate.
inadequate.
Oh.
We say it is inadequate because Lordship, so far as sentence is concerned, court has given only 6 months.
So so. Okay, give a date, no?
Eh,
We'll decide on.
On 8th for hearing. madam. It will come up.
For hearing, this is the matter for hearing only.
In the meantime, I'll find.
In the meantime, Mr. B. Prasad may file his appeal.
Lordship, kindly list the meter on Friday, date is on
Which
12th.
item? It's a new item.
Just
What
mention
item
the
is this?
Lordship, just I mentioned the meter for listing, Lordship.
Ah,
Lordship, fix the meter. Retaping, Lordship, fix the meter on
you want it for next Friday?
Lordship, next week Friday on 12th, on 12th.
Next Friday. Okay.
May it please, my lords, prayer for adjournment, my lord, in item 18 of the supplementary list.
Item 13,
18, my lord. 18.
18.
My lord, may kindly fix it for tomorrow. Actually, there is a change of councils, my lord. I have been newly engaged, my lord.
No, we're
My
not,
my lord, seen-
yeah, every day you're like
My-
listing it every day from Monday.
My lord,
No,
may I kindly submit one thing, my lord?
no,
Just one.
next.
my lord.
Sorry.
My lord,
You can, we are rejecting it if you don't come.
my lord, may I kindly, my lord, there is, because of
No,
some
no.
health-
You have asked for listing it on Monday. On Monday, you made a prayer. Tuesday, you made a prayer. Wednesday, you made a prayer. We have allowed on all days. All days we have listed it. And again today, asking for
They
adjournment.
were my predecessor councils. I am the newly engaged council.
No, we are disposing it as we
Kane
speak.
Chaudhary is leading.
Sorry.
Senior.
Please, Lordship.
If you want, we'll take it up at 2. You read the matter. You have got 2.5 hours. We did not take us more than 10 minutes. It will not take you more than 10 minutes of it.
My lord, I duly apologize, my
Sorry.
deeply apologize.
May please, Lordship. I'd like to mention criminal appeal for order. I mean, last, this appeal has related to bail,
Huh?
matter are related to bail application.
You want a bail application? Oh, you mean suspension of sentence?
Listing for me. That's good.
Is it for suspension of sentence? Okay.
Criminal.
When do you want?
before vacation as per your comment.
19th,
Okay.
19th of December. Last day. Give a day, give a day.
May I please, Your Lordship, I'd like to mention item number
Huh?
15, item number 15. Though. Lordship, today we have some personal difficulty. Lordship. My senior is not available today. Lordship. Today he is not available due to his doctor's appointment.
Why should we allow this? When do you want? Let us see this fight. Before hearing,
Lordship,
POXO matter,
POXO matter,
yes,
DNA
DNA filing
tested positive.
positive.
What more do you want? Only delaying the inevitable. Release it day after tomorrow, if you're ready, or tomorrow. Tomorrow you're
no,
ready?
Lordship, day after tomorrow.
Even tomorrow is
Saturday, I
day.
panic.
Then Monday, Lordship. Monday. Lordship. Because he is not well, Lordship.
Who is not well?
My senior.
Senior is not well, your client is also not well.
Medical report came back.
Medical report is there.
Lordship.
So, okay, right. On the prayer for adjournment made on behalf of Mr. H.R.A. Chowdhury,
Lordship.
who is reportedly unwell, list the matter on Monday. Huh? You just say, the DNA report has tested positive against the appellant,
Didn't get
which is a,
DPF.
Please, Lordship, apologies, my lord. Can we take up this matter tomorrow, my lord? My senior is not available today. It has been told that we'll be arguing the matter. This is regarding the shifting of the IMFL shop.
what has happened? You're against the relocation.
Yes, my lord.
This is against the relocation.
But usually you're on the other side.
My lord, what has
Okay.
happened here is that there is a
So yes, what has happened?
Lordship,
License given,
license is already there, your Lordship.
license
License is already
given,
there.
and has the rules 289 been followed?
Yes, it's been followed. There's an inquiry was conducted.
Yeah, where is that?
Then I'll get the inquiry report, your Lordship. There's no NIC inquiry, we'll get the
You get the
report.
inquiry report tomorrow,
Very well, Lordship, tomorrow.
very well, Lord.
right, on the prayer made for adjournment on behalf of the petitioner, who is against the relocation of the wine shop from Silpukri to AZ.
AZ,
Huh?
Azara.
Azara, no, to Azara. The prayer is allowed, miss the matter tomorrow. Mr.
R.R. Gogoi.
R.R. Gogoi, Lieutenant Counsel for the Excise Department, submit that the shop to be relocated. Submit that an inquiry has been made with regard to the shop, wine shop that has to be relocated. That is to be relocated. And the same shows that the relocated shop complies with all the requirements under Rule 289(1),
289.
of the Assam Excise Rule,
Done.
2016, correct?
Yeah.
This is the matter tomorrow.
Obliged, Lord.
What to do?
Lordship, this paperwork already prepared.
Correct.
Not hard to ask.
We have
Yeah.
received it.
Lordship.
So we can listen for hearing.
Lordship.
Okay, right. Counsel for the parties submit that paper book has been furnished to them. Accordingly, list this matter for hearing.
None.
Oh, he has not been furnished. We have.
Is that furnished? We have got a copy.
Yes, PB3 has been shown.
What about you, madam? You have been
We
given.
received.
Then give it to him. Okay, just right. Before that, you just right. Mr. Ayush Chowdhury, Learned Counsel for the appellant has been furnished a copy of the paper book in court today.
Lordship, go to now.
Accordingly, Liz is, Ms. B. Buyan, APP submits that she has received a copy of the paper book. List the matter for hearing in usual court.
Immediately after vacation.
In usual court,
They are in custody.
look, we are, let others also have a chance. Let it come in usual court. 302 matter.
Yeah.
Lordship.
You mean to say it might come this month?
After immediately after vacation, if possible.
Lordship, in this matter, there's an issue as regards service. I may be given short time, you know.
Okay, right. You have been given paper book.
No, man.
Have you got a copy? It's fair copy.
No, no, paper book has not been.
It is, we have got.
Oh. I mean, I've got.
No, let me see, Ms. B. Buyan, this is to certify that paper book in respect of criminal appeal prepared by Harvey Check. No, received copy of paper book, so public prosecutor. 2111.
Lordship will not blame me, but may blame my office.
No, no, we're
Our
not,
office to be blamed.
we're not
They didn't
blaming
stop.
anyone. We're not blaming anyone. We're just informing you that your office has received.
They do, my lord. Today also only a memo is there, PB is not there.
Okay, Mr.
Hey, how are you?
A.
How are you?
Our learned counsel for the appellant has been furnished a copy of the paper book in court today. Office note indicates that paper book has been furnished to the PP's office on 21/11/25.
Regarding service.
Regarding
We have
service,
additional PP shall obtain instructions with regard to whether notice has been served upon the
no,
respondent number.
Lordship, the report hasn't come. We have not received it.
That's what you.
10 days be
instructed.
given, yes.
We take case step.
No, আমার তো এখন objection নাই। নাই।
So there is this thing. There is this IA. Let's do the IA. IA.
No.
IA, you have filed it also.
They have filed, they've already filed, my lord.
They have filed, we can do the IA.
Tell me that the applicant has been convicted.
লাইফ
under
কাটে
section-
নিব।
Okay, okay. Okay, this is a new thing. And what about the? Okay, right, in the IA, you write. Miss Abraham. And Mr. BK Goy, learn counsel for the response number 2. Are granted 4 weeks time to file affidavit, written objection to the application under section 89 CRPC. No, out here he has used that.
Lord,
section. He hasn't used that 430. Then you write in the main appeal, you write. As TCR has arrived, agency to prepare the paper book. Mr. Abe, can obtain instruction. No. Mr. R. Gogoi appears for the point number. This is the matter. After COVID. Okay.
Yeah, in the case, my lord, I seek my lord 1 day accommodation. Only 1 day, we take
Why?
on Monday. Because my lord, last night I could not prepare, my lord, I have downloaded some judgment, my lord.
No, we'll hear you. You can give the judgment tomorrow. We'll wait for the judge.
Plus. Oh, box. I received the,
As have we given an order, right, yes, TCR has arrived. Registry to prepare the paper. In terms of the last order, notice has been served upon the respondent. This is a matter after the vacation.
Lordship, in this case also, Lordship,
Huh?
yes, service of notice is complete, Lordship.
Yes,
And Lordship, objection also filed. Now, it was for, preparation of paper book, Lordship.
My lord, that is an interim application for bail.
okay, we can take it up. You want to take it up?
As your lordship pleases.
Yes, we are ready.
Or my lord.
This is
let
the main case.
Lo-
Or my lord, let the paper book be
Let the
prepared
paper
so
book
that
be-
we can. Just to take your lordship to the.
What are your, what does the victim say?
My lord, so far the victim is concerned, my lord. She was in love affairs with my lord.
How old, how age?
My lord, as per the radiological report, my lord,
Was there any birth certificate?
no, 19 to 21 years, fine.
Oh, then,
Lordship, it is done to by Ms. Nia, Lordship. As our earlier order was there to prepare for paper book, Lordship.
that is no bar for the.
No, it is not a bar, Lordship, it is, Lordship.
Wait, let us pass the order in the main appeal, then we'll look at the IA. Right. Right, Mr.
Yes, sir, Chairman.
A. Sarkar, Learned Council, A. Sarkar, Learned Council for the paper book has not been prepared till date. This matter after the vacation. Then in the IA, let's see the IA. Acha, one more thing, wait, you, both, the matter, right? As per the letter dated 35/25 issued by the Inspector of Police, OC Kajal Gaon Police Station, Chirag. The informant has been served notice. Accordingly, however, no one appears for the respondent. Point number 2, how no one appears for the respondent number. Then, from. I think it has a point. Yeah, so this, Birth certificate was, isn't it? Birth certificate.
Birth
is-
certificate from the school, my lord, take it, not the original birth certificate.
This is birth certificate, date of birth is just
2003.
19 days after birth, so it cannot be by the school. 19 days after birth.
2007.
He was admitted on the 18th day or something of her birth. Cannot be. Madam, there is one thing out here. It appears that there were two cross cases. Two cross cases. But there was only one set of evidence. Now, the issue is that the evidence has to be recorded separate for both the cases. Now, if it has to be recorded separately, now, we have to remand the cases back. However, evidence in any event has been recorded. Now, that evidence that has been recorded in which case? If that can be identified, that evidence of this person, 1, 2, 3, all this is in relation to one case, then for the other case, a separate evidence can be taken.
Lordship. In that regard, Lordship, the acquitted person should have received the notice, Lordship.
But they're not coming, what to do? We cannot keep it hanging also forever. With Kingdom Come.
Lordship, that is also there. And for this case, who have been acquitted, Lordship, informant is there. For the, in their one case, some are acquitted. For them, learned friend is here. And for respondent also, but
Acha,
Three-
there are two cases,
two
correct?
cases. In the first
One is
case-
the 131 of 2014. In 131 of 2014, they have all been convicted.
No, Lord. The acquitted persons have entered appearance. They have come. They have 131, all are represented. The
No, no.
acquitted persons.
So conviction has been done only in one case.
Yes, Lord. We have come against that.
We have come against the conviction against in
131.
131. In 131, all the accused persons were convicted or not? That is the question.
No, Lord.
How many accused persons were there in 131?
5 have been acquitted, Lord, in 131.
5 acquitted, how many convicted?
The remaining 8.
Remaining 8. 5. Acquitted appears to them. So the convicted persons have filed the appeal
Lord,
in 131. So 131, everyone is there.
Everyone is there.
Now, 347. In 347, they are all acquitted.
all acquitted.
How many of them? So they are not here,
They are not.
and we need to issue notice to them.
Yes, sir. Notice has been issued, but not served. Okay. As per the last office.
Now, the only thing is this. The evidence that has been recorded by the learned trial court is in relation to which case? 131 or
One-
347?
131.
The judgment itself would show that in the first page of the judgment, only session case number 131, 2014 has been mentioned. Thereafter, the names of accused has been mentioned, and thereafter, and session case number 347, only 2015, and the names of the accused thereafter comes. So precisely, it will be difficult to infer as the learned session judge. Distinct accused in mind.
Now, let us see the charge sheet. In the charge sheet of 131, how many prosecution witnesses are there?
there is an order of your lordships, 15/6/23, there paragraph 8. Lordship's category is stated, for example, the witnesses who have been recorded in one case and the evidence was relied where the witnesses were recorded in the other case, their evidence was relied in the other case. So that was the conflict in paragraph. In your lordship's order itself, 15/6/23. It's a detailed order, para 8. 15/6/23. Right.
Okay, so, no, let us see the chart sheet. Chart sheet in 131. So all the evidence that were recorded in 131,
No lordship.
huh?
No lordship. Two sets of evidences were there,
So
but
they were so let us differentiate. So there are 26 witnesses in 131, correct?
lordship.
And if there are 26 witnesses in 131, how many of the witnesses evidence was recorded in 131?
In the paper book, lordship, the appendix, page 205, there is the prosecution witnesses list is there. The ones who were recorded in the two
That's
cases.
what I'm looking for. Paper book is here. Okay, okay.
205.
No, I think this one. What is the TG 150? Okay, so out here, chart sheet. Now let us see. So there are 26 witnesses. In paper, there are 26 witnesses are here.
205, page number 205, 26 witnesses are there.
20. Zero five.
So 347. So 347, there is 10 equity.
Huh?
For the other case, lordship.
Let us see the chart sheet of 347.
Evidence is not with us.
Huh?
In regard to 347 lordship, it is not with us. Evidence is not with us. But the names shown lordship are not same person. They are different.
No, where is the paper book for, where is the records of 347? Is it there? Is that for 347 or is it joint? Otherwise, what we can do is, but the problem is again remanding that acquittal case when they're not here.
That was lordship's initial view, because it will get affected.
They will get affected naturally. But we're deciding the entire, their rights are going to get affected. But if they don't come, now what to do? We keep it pending or what is to do? Matter on the 24th, 7th. It will notice. So, of course, it will notice two learner sections that are So, then second section that. So it's awesome.
Because
Learning
I
section,
chose-
huh?
that is it. Learning section that I believe the notice were not issued through that paper. AD card was there, means by post it was there. For the concern, police officer. Of the impact.
No, it has to be done. Right. Right, Mister?
VH or the dealer.
8,000, and you are for whom?
And for one of the appellants in this
And
case,
Mr.
A Ganguly
A. Gangus.
for
Then
Tajuddin
counsel-
Bhuiya.
Counsel for the appellant. Also heard Ms. A. Pega, Leonard A. PP, comma, Ms. F. Hussain. And you are, Mr. F. Hussain for the comment and Mr. A. Huff for. Who responded number? Three, 8, 9, 11, and 12. That's fine. This court, by order dated 15/6/2023, has made an observation that the procedure to be followed by the Leonard Trial Court in terms of the decision of the Honorable Supreme Court. For deciding two cross cases. Would require the setting aside of the impugned common judgment dated 16/2/2022. As the same would cause prejudice to the accused person who had been acquitted in second case number 347 of 2016. This court had directed the registry to issue notices to the accused person, to the acquitted persons in second case number 347 of 2000. The matter has been pending in the court for more than 2 years. As notices have not been issued to the acquitted persons in section case number 347 of 2015. This court, by order dated 29/4/2025, has directed the registry to issue notice to the acquitted person in section case number 347 of 2015 to the learned section Judge Barkita, who was to thereafter furnish a report regarding service of notice upon those persons. However, no report has been furnished by the learned section Judge Barkita. On perusal of the office note, it is noticed that the registry has not issued notice to the acquitted person in section case number 347 of 2015 through the learned section Judge Barkita. The registry is accordingly directed to serve a copy of this order to the learned section Judge Barkita, who shall thereafter take steps for service of notice upon the acquitted accused person in section case number 347 of 2015. The learned section judge shall thereafter submit a report in this regard. This is the matter. You take.
There is also a IA in item number 12. I filed a bail application in respect of one of the accused, Tajuddin Bhunia, Lordship. He continues to remain in jail for the last 8 years, Lordship. And Lordship, since 7 of the accused have already been enlarged on bail, he and other person, there is another accused person who are in jail. And since Lordship has already expressed the intention that the matter in all likelihood is to be remanded back, and this accused person was all in all on bail even during while the trial was going on. So there is a suspension of sentence from this accused, Tajuddin Bhunia. In that application, Lordship, they were required to file an objection. Objection has not been filed. In item number 12.
It was ordered for RR Kosik Learned Council. Lordship. I will inform
IA
you, Lordship. He may file also. Lordship.
When did you file? Let us see the hearing.
IA 463/24.
Is it listed today?
Yes, sir.
Madam, since April he is not filed.
Lordship, I will inform him. Maybe if not Lordship, then I will file.
We didn't have to file, we'll allow the bill.
Lordship, but that's mandated 10 years. Lordship,
It's not
well,
mandatory.
Lord-
Where does it say, ma'am?
Lordship, I already, Lordship, will grant something for the hearing. See,
15th of May
no,
2024.
no, it said they can find it.
No, that
They ordered in 29, Lordship.
and 29/4/2025 notice was issued and they were required to file their objection by 23rd of May 2025. He's lingering in jail for the last 8 years, Lordship.
And 2 weeks, Lordship, within that means, today is Lordship, I'll file within this week, Lordship.
You file within
Coming
this
week, 19, Lordship. 19, no,
You
Lordship.
file within this week.
Lordship, 12.
Yeah,
file?
this week means tomorrow.
Tomorrow I'll file in Monday or Tuesday. I'll have to, no,
I have annexed the bail orders of all the other appellants who were granted bail.
and I will inform him also, Lordship, maybe he may be.
You see the decision, the order passed by us earlier.
Lordship, all are
That has basically made everything redundant. This is just now,
formal.
it's only thing of formality.
Formality.
We are waiting for the accused to turn up.
Lordship,
Once they turn up, then that order will take up.
Lordship.
Just to finalize it. And then everything goes back.
Yes. And this is precisely the reason why this bail application has to be moved, Lordship. Because During the trial, he was all on bail, Lordship.
Let him go out.
Yes.
Right. Has Mr.
A Ganguly.
Thousand for the applicant.
17 yeah, 12 lordship.
We are planning to dispose of today.
Yes.
The 12, I'll file the objection.
No,
lordship.
no,
No, objection can file tomorrow.
already it is pending for the last 1.5 years.
Because above 10 years lordship.
And this deliberation is continuing for the last 2 years.
We're not doing it on merit, we're doing it on the basis of that order. pass.
Only
Yes.
one week lordship. Only one week.
Objection you have not filed. Sufficient opportunity was given to
No,
them.
lordship. Only 1 week. lordship.
No.
Yeah, you don't want to file what to do. No. For the applicant,
Lordship may reflect RR
Faizuddin
Huh?
Bhuiya.
RR costing lordship. Not I. Because 10 year more, above 10 years lordship. So lordship.
when we show his name, we are here.
I know.
He get a shock, he'll be saying that I was attending a marriage function and suddenly in the High Court, objecting to a bail petition.
Lordship, then let it be on at 2 lordship. We will be there. I will ask him. Maybe he may file or I'll just get the information from him. He's there, lordship. RR costing. Do that, lord.
Otherwise,
Yeah, anyway, let us pass the order.
Lordship, lordship.
The name fixing that we can do later on, anyone. Yeah, for the applicant,
Faizuddin Bhuiya.
Faizuddin Bhuiya, who has been convicted pursuant to the judgment dated 16/2/2018, passed by the learned section Judge Barpita under section 302/149 IP. And sentenced to undergo imprisonment for life with a fine of rupees 10,000, in default, how much?
Rigorous.
Huh?
A fine of rupees 10,000 each only, and in default to rigorous imprisonment for 3 months.
In default, rigorous imprisonment for 3 months.
There are convictions of 147 under 148.
Huh? Stop. He has also been convicted and sentenced under section 147
148.
and 148 IP and sentenced to undergo sentenced to pay a fine of rupees 3,000 under section 147 IPC and a fine of and to pay a fine of rupees 5,000 under section 148 IP. Correct.
As well as under section 323.
He was also sentenced to under what? What was the sentence under?
5,000 each in default to undergo RI for 15 days each for offense under section 323 IPC.
He was also sentenced to undergo RI. No, sentenced to
Pay a fine.
to pay a fine of rupees 5,000
5,000 each in default to undergo
in default to undergo RI for 15 days.
each for offense under section.
Each,
323.
forget it.
Yes.
Next. The learned counsel for the applicant submits that in view of the order dated 15/6/2023 passed in the main appeal, which has basically settled the entire matter, the entire appeal, wherein the trial is to be, wherein the case is to be remanded back to the learned trial court for adducing evidence separate. Huh? They're not 24/7. I said physics. Physics then. What have I said? Come on. The the petitioner sentence should be suspended and he should be released on bail. As seven as co-applicants, co-appellants, seven or how many?
Here,
Seven seven co-accused have already been released on bail, is it?
five in my appeal and one for position. Six.
Six co-accused. Six co-accused have already been released on bail. Come on. Their names are, what are their names? Yes, Mr. Counselor, what are their names?
Their names are,
Give their name.
yes. Amir Bhuya,
Where?
Amir Bhuya in criminal appeal number
Yeah,
85.
you just say, stop. They have been granted bail on suspension of sentence. Why orders passed IA criminal 229 of 2018,
I have an expert.
comma IA criminal 672 of 2018. Seven nine one of 2018, 263 of 2019, 82. No, this is criminal appeal. 82, this is not it.
All these four orders are in criminal appeal 85/80.
Arising out of criminal appeal 85 of 2000. Which is being heard along with criminal appeal 82 of 2000. Three. Four. Five. Six. Seven. There are 7%, not six. Seven, not six. Yeah. 7%. No. Eight, seven it is. All seven, just like seven. Next. Yes, Mr. Kaushik, anything to say?
Here, I was supposed to file objection, my lord. Yes, my lord, but if I remember, my lord, what has happened, my lord, here, the copy which I got, my lord, the IA, that objection, that order portion was not there. Due to that, my lord, I was not able to file, my lord. And to be honest, my lord, after that, I missed this, my lord. In any way, it is 2018 matter, my lord, perhaps 10 years conviction. Like, my lord. Or else the objection may be recorded.
Correct. Mr. R.R. Kaushik, APP. In the beginning also you put R.R. Kaushik, Mr. R.R. Kaushik. When APP submits that, the case should not be allowed. Even though the order dated 15/6/2023 has, when it passed in the main appeal, has basically decided the whole issue. Like that. On considering the order dated 15/6/2023 passed in Criminal Appeal 82 of 2018. We are of the view that as the matter would in all probability be remanded back to the learned trial court in terms of the decisions of the Supreme Court mentioned therein. And as the applicant was on bail during trial, the sentence imposed upon the applicant pursuant to the judgment dated 16/2/2018 passed in Sessions Case number 131 of 2014 against the applicant hearing to be suspended. Accordingly, the applicant is allowed is to be released on bail on a bail bond of the fee. How much? 20,000. With one surety of like amount to the satisfaction of the learned trial magistrate, trial court.
Next session judge got it.
That is the session judge got it. That's all. Okay. The eye of the only this one. Thank you. I is the point. Is the power.
DPO.
Doctor, I was for item number 11, man.
Yeah,
The Boramat.
item 11.
Together, I think.
Yes, yes.
I have no record my name that.
Oh, you want your name to be recorded?
Yeah.
What is his name? Mr. Sir.
Okay.
One of them. Successful. No, don't be. In the thing we have said, Mrs. So and so appears for the. You know that. Yes, yes. Yes.
This appeal is against the judgment and order dated 8/12/2020, my lord, under section 302. Imprisonment is for life with fine and in default arrive for another 2 months. Here, my lord, case is projected as such that accused due to cut injury that victim died, my lord, by the accused. There are 15 injuries in medical evidence, my lord.
The deceased had 15 injuries.
Yes, my lord.
Cut injury.
Cut injury by the
15.
15 as per medical report. And evidence, my lord,
How old was the victim?
uh, 22 years.
How much?
22
22.
lordship,
How long was they married?
5 years.
5 years.
They have a
They have
child
a
of 4
child
years.
also.
Any witness?
There is no eyewitness.
No eyewitness, but he himself went to the police station case, then he surrendered.
He surrendered
But-
with doubt,
Without.
With the dog.
but no such
what-
recording of evidence. His statement was not recorded, neither any recording of evidence of the victim either. For some while she was conscious as per evidence shows me, no? Later on, she became unconscious, my lord. And all the evidence is prosecution witnesses saying that she told that the accused is involved in this incident. Only they are the two
No,
persons.
no,
who
he
said
surrendered with the dove.
doubt.
Did he confess to it?
Nothing. Neither police has recorded
Recorded
his
no confessional statement, but lordship, he's 313 lordship.
Haha.
There is no, all questions, lord, all questions put on him, lordship. He have replied in, it is false. Your wife died, false. Just simply I'm saying, but. if
Any
that-
alibi? Where did the?
He is definitely in 313 my lord. There is a land dispute between the
Last week,
Acha, who is the person who died?
wife,
wife.
Why?
Informant is the stepbrother of wife, my.
Informant is step brother of wife. So
There is some, he tried to explain, my lord, there is land dispute some.
between whom? Between
Like
him?
wife and other the stepbrothers, my lord. So as a matter
But,
of,
acha.
that is why
So he's trying to put the blame on his step brother.
his stepbrothers, the informant. One explanation is there.
that is last question, lord.
Last question.
But no such lordship regarding stepbrother have marked.
And prosecution witnesses tried to reflect, my lord, that there is some quarrel in the previous night, my lord. But at the same time, they also admit that they have a peaceful life without any quarrel.
When did she die?
See, that
What time?
different witnesses say different time, but timing is from 8 to 10, my lord.
8
In the
to
10,
in the
between
evening.
evening, late night.
Okay, 8 to 10. As per the medical report, 8 to 10. Postmortem, when is the
PM report is lordship.
when is the time of death?
Dead body was arrived at lordship 3 PM.
Where was
To
where was the appellant at that time?
He was in the PS lordship. Oh, he was,
already
he
surrendered.
surrendered lordship along with the
same
dog.
day.
Same day lordship.
What time did he surrender?
About after 10, my lord.
After 10.
10.
Oh, it's not after a few days or something.
No,
No,
no.
not immediately,
Immediately.
immediately.
On the
After
day
the
of
occurrence,
incident.
he with the dog.
So any citation?
So lordship, I
You're
tried
only giving us fact, you're not assisting
that
us with judgment.
circumstance could not
So
prove the
what to do?
case of prosecution, my
Huh?
lord. Circumstantial chain is not complete as
Why?
because contradictions are there, my lord.
What are the contradictions?
That the prosecution tried to say, my lord, regarding the quarrel for which that occurrence took place. Date in between the husband and wife, accused and the victim, my lord. But at the same time, in their cross-examinations also, my lord, they say, they admit that they have a peaceful life without any quarrel, my lord.
Where were you during that time? Did you give any evidence that you were not in the house? when it
Defense is not there, my lord, that
Yes.
I admit. No
That
defense
means
is-
you were there.
Except
With the
except that
foundational-
explanation,
Then
my lord,
you have to give your, then the
No,
then
no
the first
independent-
burden of proof.
defense
In a way,
witnesses.
106 comes into play.
Mm.
So it's a weak type of evidence. Still,
Only this people.
and it occurred immediately.
Immediately.
You went immediately to the,
Surrender to the outpost,
Surrender to-
concerned outpost, thereafter case was registered.
to
in
do what? To do what? You went to do, to basically, you felt guilty and gave yourself a
But no such statement is there, my,
statement by whom?
that accused my.
Why?
They have not recorded, police has not recorded any statement.
You became white. That is their fault. They did not do that. They should have done it. They should have taken you straight away next day. 164.
Yes, my, no such thing.
Now, definitely, that's the of course. It's okay. Okay. The weapon is exhibited or not?
We can open, not.
Neither it has to send for any forensic. No.
And it doesn't-
Forensic there.
But we
there's
gave
no-
the weapon.
Only says.
Now, that is a circumstantial evidence.
No.
You surrender with the weapon. The third circumstantial evidence is the fact that you did not explain
No explanation.
as to how your wife died,
No, that explanation is.
though you were supposedly in the house because you have not taken the plea of alibi.
No, that plea was also not taken.
If you have not taken, then you were in the house.
Neither any defense evidence was laid in. Independent.
Any citation?
Lordship. Surrender. Lordship, in the Lordship, gross part of the Lordship, the injuries, page number 37, Lordship, in the medical Lordship, doctor. I conducted the postmortem at 4 p.m.
So
The injuries were caused with sharp weapon and the same way inflicted consecutively. Brutally murdered.
can there be, there is no other hypothesis. You see, if you are giving the plea of alibi that you were not there at the place of occurrence during the time the incident occurred, then maybe we could think that, there's someone else was involved.
Yes.
And
That is
when there is nothing why you stated
nothing.
that you were not there, that means you were there, and that's your wife, and it's your house.
He voluntarily went to the police station
Immediately after he surrendered,
along with the dog.
along with the dog.
Along with the dog. It's not that the villager has taken him there.
Okay, we'll meet again at 2 o'clock. Yes. Or should we pass the order now?
Lordship,
It's left.
see,
We are having a lot of pending matters.
Lordship, Lordship.
We're not dictating in court. Now the problem is this criminal matter is highly problematic.
Lordship,
If we dictate in court, it takes a long time.
long time, Lordship.
Long time.
Evidence that has to be.
Even for what you all have said,
Lordship.
not to make it reasonably understandable. And
That is a-
we've got to make it law. Yes.
With regard to item number 17, Lordship, we want time. With regard to item number 17, Lordship.
Just a minute. No. Just a minute. We're not finished. Third, Miss
Amber.
M. Barman, learned amicus curiae for the appellate. Also heard Miss A. Nizam, learned APP. The appellant has put to challenge the judgment dated 8/12/2020, passed by the additional section Judge Bilasi Para. In section case number 18/2019, by which the appellant has been convicted
For life.
under section 302 IP and sentenced to undergo
Life.
rigorous imprisonment,
RI for life.
rigorous imprisonment for life
With a
with
fine
a
of
fine of rupees
5,000
5,000, in default,
in default 2 months.
2 months SI or 2 months.
RI.
Right, 2 months.
RI.
The appellant's counsel submits that there is no eyewitnesses with regard to the murder of the appellant's wife. He also submits that there is no circumstantial evidence to prove that the appellant had killed his wife with a sharp weapon, even though the appellant had surrendered before the police with a doubt. The learned amicus curiae submits that the weapon that had been seized by the police from the appellant had not been sent to the FSL for examination.
And another thing, my lord, there is no blood stain in the dog.
And there was no blood stain
in the
on
dog.
the scepter, on the duck. That's all. Anything else? There must be something else.
Yes, that
What?
I would like to that discrepancies to point out, but as lordship,
No, we'll hear you after. Well, yes, the next, who you wanted to make what?
My sincere apologies, I thought that matter was over and I came for mentioning.
Yes, yes.
With regard to item number 17, Lordship, we have a joint here. The senior is there. We are sitting some time, Lordship. Can it be fixed after new Lordship? Item number 17, Lordship.
Okay. We'll hear you. What is it? We can hear you now. What is it? Short point, 5 minutes, short point. Short point. Tell us. Tell us, we'll take up everything.
My lord, the appellant was seeking, my lord, that
You want the fight? Yes. Short date.
yes,
We'll dispose it of now. Yes.
the appellant was seeking, my lord, the
You want the regular scale of pay from a retrospective
yes,
date.
yes.
That's
On the
it.
date is given, my lord.
Correct. And High Court has given you that regular scale of pay from the prospective date.
Yes,
That's the basic case.
and I'm working from that date, my lord.
And you are working from which date?
That
Of the earlier date.
earlier date, my lord, as a junior engineer, my lord. I'm the only
We
junior.
have done our part, Lordship.
Yes.
Yes,
Yes, yes, exactly, my lord.
Exactly, Lordship.
No,
Lordship,
I'm in a
it
better
was-
position, my lord.
It was accepted by them, Lordship. Exactly.
From the date, my lord, 1/7/2014, that was recommended, my lord. That was recommended, my lord. I filed, my lord, in the year, my lord, 2022, my lord.
22, Lord.
Because others are, my lord, junior to me. Others are junior to me and not from my category.
They were given from when?
Lordship.
24.
Lordship.
And they did not, there was no recommendation for that. I have annexed the recommendation order of my PC, lord.
Okay, Lord. Exactly, Lordship. And it was accepted by them, Lordship, in the hearing of the.
Lordship will hear it, my
Lordship.
lord, then I can satisfy.
Lordship, even they did not submit their particular documents. We
No,
sought
Just
documents.
a minute, my lord, only the point also. Kindly page 58, your lordship. No, my lord, thing is that, my lord, page 58, only limited prayer, my lord, page 58. That is the, my lord, send the municipal board have recommended, my lord. Yes.
Exactly, Lordship. State government, Lordship, because
But
we did not have power,
Director
Lordship.
answer is, my lord, administrative delay, that there is no approval is required. That
Lordship,
is
which has been clarified only during the pendency of this writ petition.
My lord, the director
Earlier,
answer
before
is, your
Lordship, we are
lordship,
not-
see. Page 84, your lordship, see.
Lordship, it was dealt extensively.
My lordship will hear it, my lord.
Lordship,
No, we've heard it,
Lordship, the
nothing-
matter was heard extensively during writ
No, no.
petition. But I don't know why they have filed this.
Lordship will see
there's
that,
no point hearing you more.
lordship will see the fault. It is not my fault, my lord, it is the
Lordship, it was-
department.
Exactly, Lordship. No, we have also done our part, Lordship. Lordship, we have processed it.
My lord, your lordship, presently also they are not paying.
No, Lordship, we have.
That is the thing, my lord.
Yes, Lordship, we have presented the matter. Lordship. Lordship. We have
The
already.
recommendation is only a recommendation.
No, but
Unless it is,
Lordship, we were not aware that whether we are possessing the power after the
Right,
during the
sir.
pendency.
B. Bhavan.
P. Barwal has counsel for the appellant, also heard Mr.
Yes, Sarkar, Lordship.
S. Sarkar has counsel for the
For the board, Lordship.
Municipal board.
Municipal board.
municipal board.
Badalapur municipal board. 4 and 7, Lordship.
Dismiss.
Lordship, 4 and 7.
My lord, only thing, my lord, lordship, they should pay the as per as. C.
Lordship, we are processing,
That's
Lordship.
what observant. They are not paying, my lord.
A time frame may be given, Lordship.
That's the.
We are not objecting, Lordship. Lordship, a
That
time
may-
frame may be given, Lordship. We are not objecting.
That may.
Yes.
My lord, before I start my submission, my lord, I would once again with folded hand make one submission, my lord, that I am being led by senior advocate, the Chaudhary, that he is not.
No. You all have made, enough times we have listed it. You had asked on Monday for listing, on Tuesday, we listed on Tuesday. Again, you had asked on Tuesday to be listed, yesterday we listed. Again, yesterday you listed, for today we have listed. So we have listed it enough time. 3 days in a row we have listed for you. And we have to come prepared every day because we forget. And so we will decide if there is if it's in your favor, good. If it's not in your favor, you go up. You can go. There's always an avenue for you. Yes, tell us.
My lord, may kindly have page 181.
Yes,
May I read, my lord?
yes.
My lord, this is the vacation notice I had received on 11/6/2024, my lord. If I may read, my.
Yes.
Please refer to 60 days notice dated 16/7/19 issued under section 13(2) of the SARFAESI Act. The amount due to the bank as on 29/5/19 is rupees 42 lakhs, 42 lakh with further interest and cost until payment in full. Despite the above notice, the amount due to the bank has not been paid to you. My lord, then the property, my lord, in the next paragraph. My lord, against this notice, my lord, we had preferred the SA, my lord, before the DRT Guwahati, my lord. If my lord would, my lord
So
would.
this property
Yes, ma'am.
has been sold, correct? Auction.
Yes, it is.
When was the auction done?
Auction, my lord. Auction. My lord, in.
Well, this is the possession notice, my lord. Option, I am not aware, my lord.
No, this has been, you see, Mr. Council, what is it? You see, 29, 12, 20. That this property has been sold off in 23.
Scale certificate was issued.
Yes, space certificate is issued in 23. Now, you see one thing. So this vacation notice was put to challenge.
Yes, ma'am.
In this misappeal, in this in SA 71 of 24.
Yes, ma'am.
Correct?
Correct.
In before the DRT.
Yes.
Now DRT has this vacation notice
Yes.
arises from what issue? From the sale.
From the sale.
From the sale. Now, have you challenged the sale?
My lord, yes, my lord. In
Where?
the, my lord, in the essay, my lord, there are portions, my lord. My lord would kindly have page 172 onward.
Page 170.
That is my petition, my lord, the essay.
No, this is stay.
Stay and also.
Stay of the impugned vacation notice only. No, you have not challenged anything prior to this vacation notice. In this 71 of 24.
Yes, ma'am.
Let us see a prayer in this 71 of 24.
Yes, ma'am. My lord, may I kindly have page. My lord, 179.
152.
179.
179.
Yep.
This is the IA in the essay.
Yes, ma'am.
This is IA 418.
Yes.
Where this is on 154.
Yes.
Page 154. You
Page
check
one.
Your prayer.
Yes, ma'am.
Your prayer is for declaring the vacation notice bad in law and to satisfy. Now you have not challenged the sale. How this vacation notice has been issued in pursuant to what?
My lord, this vacation notice has been issued, my lord, pursuant to the, my lord, the sale certificate, my lord, 29/12/23, perhaps.
Come to page 181.
Yes, my.
Please refer to 60 days notice dated 16/7/19. Where is the 16/7/19? Where have you challenged the 16/7/19?
Yes, my lord. My lord, previously also there were some litigations, my lord.
Correct. We know. To us.
Yes.
Let us try to understand the whole issue. Where is this notice dated 16/7/19?
My lord, may I have just a 1 minute?
Yeah, it's page 48. Now you come to page 7, page 47.
47.
This is the first thing. That essay 93 of 20. Cause of action, all 16/7/19. So this is the start of the case. 16/7/19. Now you come to page 48. What is the prayer? The prayer declares all such action present leading up to issuance of notice dated nil. I don't know, they have not put, they have blank. Possession notice dated issue nil again. So basically, they have challenged all this here. 13 to 13.4 they have challenged. Now this 13 to 13.4, which is pertaining to 16/7/2019, has been dismissed. Has been dismissed by the DRT. Now you have put that now, and then this 93/22 has been dismissed by the DRT. Correct? Has been dismissed and you filed a review
Yes.
against the dismissal. The review is still pending. In the review, there is no stay order issued. Correct? If there is no stay order issued, what does it mean? As on today, the decision passed in SA 93/22 is still in force as a plain finality. Now, the present vacation notice that we are challenging arises from the earlier notice of 16/7/2019. And the challenge made to 16/7/2019 is gone. So unless you challenge that SA 93 of 2022, you cannot challenge the consequential order. That's all. There's nothing else. You have to challenge SA 93 of 2022, the decision made therein. The rejection of the SA 93 of 2022 has to be challenged. Your review is pending, that's a different thing. So what you could have done was withdrawn your review, filed an appeal against that 93 of 2020, along with this vacation notice. You have not done. End of the matter. What is wrong now? Your vacation notice has been correctly dismissed as being the IA in that vacation notice has in that SA 71 of 2024 has been correctly challenged, has been correctly set aside. Because the earlier order is still standing. Read 185. Correct. There is no problem. And we have noticed that you have not been fair to the court. For the simple reason that when you come to page 48, you have very conveniently left the dates blank. So that it took us another maybe 2 minutes to search out what you were really challenging.
I am also not proper.
Huh?
My lord, I had also received a brief today only. Just
Maybe
fix for
we
tomorrow,
have
my lord.
received
I
it.
apologize, man.
No, it's okay.
I am also not well, my lord. Actually.
You might not be well, but now we are dismissing your.
My lord, just one day may be given, my lord. Tomorrow.
Heard, Mr. What is your name?
My lord, then,
Huh? P. Sharma.
my lord, let me just draw the attention of the honorable court.
Huh?
Just a few submissions then, my lord.
Yes.
My lord, may kindly have page 187, my lord.
186. Yes.
My lord, this is the appeal, my lord,
Correct.
which we had filed before the DRAT, my lord.
Correct.
Here, my lord, we had stated that, my lord, certain points were not discussed in entirety by the DRT, my lord.
Well, in this petition, in this debt recovery appellate tribunal, where is the challenge made
My lord,
to the dismissal of your SA 93 of 2022? You see, out here, this page 187 is only a challenge to the dismissal of your IA made in 71 of 24. It has nothing to do with a challenge, with the dismissal of your SA 93 of 2020. And this matter pertains to what? You took a loan,
yes, ma'am.
you gave your property as mortgage, correct? You could not repay the loan. They issued you 13(3), 13(4) notification under the SURFACE Act, which you put to challenge in 93 of 2022. That was dismissed. You filed the review. Review still pending. Thereafter, the vacation notice was issued. You put that to challenge. And you also file an application for stay of that vacation notice. That stay of the vacation notice was dismissed. And accordingly, you made a challenge at page 187 to the dismissal of the IA in that 71. Correct? Now, after now that was dismissed as not being maintainable. Then because of what? Because of the 93 of 22 decision, we are still holding the field as on today. Nothing survived. What you can do if you want for how withdraw. You can withdraw and otherwise, but then again, this is again they'll cause trouble. Everything is quite, you got to read a little bit, no, otherwise. Yes, keep going. Right, Mr. Chairman. Yes. As doing it rightly, they appellate tribunal has.
Yes, sir.
Right, Mr.
Today I
P.
filed. Today I filed.
Right, Mr. P. Sharma, Learned Counsel. Petition. This petition. Also heard Mr. UK Goswami for his point number 1. That's all.
Why not withdraw with liberty to
But the others, though, we didn't.
why not withdraw with liberty kind?
No liberty. What liberty?
No, liberty may kindly be granted, matter.
Liberty for what? Okay, let us write down the fact, then we'll allow you to withdraw. So that when it comes next, we still remember what it is. Otherwise, you've got to go through a lot of this quite thick. Okay.
Only the liberty may kindly be.
We'll see. We'll write down the fact. Right. The petitioner has put to challenge the vacation notice dated 11/6/2020 issued by 2024 issued by the Punjab National Bank. Informing him that he needs to deliver possession of the secured asset which the petitioner had put as security / mortgage for the loan taken by him from the PN. What do I say? Had submitted. In as much as the said land has been sold by auction on 29/12/2023 by way of a sale certificate. Next, the petitioner's counsel submits that the vacation notice dated 11/6/2024 had been challenged by way of SA 71/2024 along with IA number 418 of 2024 for stay of the vacation notice before the DRT got. IA 418 of 2024 was however dismissed as not being maintained by the DA. Next slide. The dismissal of IA 418 of 2024 was put to challenge by the appellant, by the petitioner, before the DRT, before the Debt Recovery Appellate Tribunal, Kolkata. However, The same was dismissed by judgment and order dated 17/11/2025 by the appellate tribunal on the ground that the same was barred by the principles of res judicata, in view of the issues being raised in Miss Appeal 72 of 2025, having already been decided by the DRT Guwahati in SA 93/2022. Next. The question, the facts of the case in brief is that due to the petitioner not repaying his loan amount taken from PNB, the bank had issued notices under section 13(2) and 13(3), 13(4), 13(2) and 13(4) of the SARFAESI Act to the petitioner. The petitioner put the same to challenge by SA 93/2022. What have I said? Really. Before the DRT, along with IA 581/2020. The petitioner in SA 93 of 2022 had challenged all actions taken by the PNB till the time of issuing the possession notice. Had issued, had challenged. Had challenged the notice dated 16/7. The notice dated 16/7/2019, 2011/2019, and possession notice dated 14/9/2021. In SA 93 of 2020. SA 93 of 2022 was dismissed by the DRT on 19/10/2020. The petitioner thereafter filed review application 10 of 2023 against the order dated 19/10/2020 passed in SA 93/2020. The review application is still pending before the DRT. Next up. The petitioner's property which had been put as security/mortgage for the loan had been sold by way of an auction, and sale certificate in respect of the same was issued to the buyer on 29th February 2020. The vacation notice, the impugned vacation notice dated 11/6/2024 issued by the bank was thereafter put to challenge by the petitioner by SA 71/2024. Along with IA number 418 of 2024. Wherein the petitioner prayed for stay of the vacation notice dated 11/6/2020. Next para, IA 418 of 2024 was thereafter dismissed as not maintainable. Being aggrieved, the dismissal of IA 418 of 2024 has been put to challenge, in Miss Appeal number 72/2025, which was dismissed by the Debt Recovery Appellate Tribunal from Kolkata by judgment and order dated 17/11/2025. 7/11. 7/11. 7/11 or 17/11? 7/11/2025. On the ground that the same was barred by the principles of res judicata. We have noticed that the dismissal of Miss Appeal number 72 of 2025 by the appellate tribunal has been put to challenge in this rate petition. We have noticed that in Miss Appeal number 72 of 2023, next para, the petitioner has not put to challenge the order of the DRT dated 19/10/2023 dismissing SA 93/2020. Further, no stay order has been issued in the pending review application dated 10 of 2023. Pending in the DRT. I would allow. Yes, sir. No, pretty process is absolutely, there's no interview requirement. He only wants, actually what he will have to do, he'll have to withdraw the writ. And then challenge the 93 before that is the only. Otherwise, we direct that the review fee. So you decide what you want to do. So do we take a final decision on this or you want to withdraw now? I don't withdraw with liberty. With liberty to do what? I have to go against minor one more prayer, minor. No. We're not allowing you to oppose it. There's no place. That's fact. There does not appear to be any infirmity in the decision of the learned appellate tribunal in dismissing Miss Appeal number 72 of 2025 as the order dated 19/10/23 dismissing SA 93 of 2022 has attained finality as on date, until and unless the review petition gives a order to the contrary.
SA 71 of 2024 is still subject.
Huh?
SA 71 of 24 is still there.
SA
Only the IA
71
has been dismissed.
Correct. Yeah, that you go there, but your challenge to this case is gone. You see, you have challenged only the vacation notice in this 71. And the 71, by the way, is connected to that 93. So,
Hello?
uh, even 71 has been held to be not decided, not dismissed, but observation is already there. Observation is already there. Okay, so just one part to that. We have also seen the order dated 19/7/2024 passed by the DRT Guwahati in SA 71 of 2024, where it has been stated as follows. Inverted commas, therefore, comma, this tribunal has no jurisdiction to decide and adjudicate afresh the same issue that which had already been decided by its order dated 19/10/2023. So this basically, this was basically in the IA, dismissing the IA. Dismissing the IA, but this will also take care of the entire 71 of 24. I mean, yes. So the above observation had been made in respect of IA number 418 of 22. That will give you later. So at this stage, you know what to do with this. In view of the above reasons, we do not find any ground to interfere with the judgment and order dated 17/11/2025 passed by the appellate tribunal for the this petition according to the one observation. Okay, you just type page 186 and you put A2. What is the date of 19/7/24, no? 19/7/24. No, no, put that. Nineteen seven twenty. Acha, we have forgotten to put one thing. This is the one where you were supposed to give 10 lakhs and you did not give. You also have got a police case against you. Ah. You're lucky we did not mention that. No. Okay, just write one more paragraph. We have also noticed. What happened to the police case?
My lord, I have to seek information for that. Well, I have received the bill today morning.
Just give us the file. We just
There is a bail order, otherwise, my lord.
but
They appended the annex.
you have filed a writ petition against which order?
My lord.
Next paragraph, we have also noticed that when the bank had issued, when the bank had taken possession of the secured property under section 13(4), read with rule 8 of the SARFAESI Act, and a sale notice of the security had been issued on 8/7/2021. The petitioner had approached this court by WPC number.
My lord, would have paid 68, man. 68. 67 is
That by WPC number 3692
3692 of 20.
of 2021. Okay. Full stop. This court had thereafter directed the petitioner to deposit an amount of rupees 10 lakh with the respondent bank. However, the petitioner did not deposit the rupees 10 lakh. This court, in its order dated 16/8/2021, passed in WPC 3692 of 2020, had also observed that in the meantime, auction already taken place, and that the highest offer of rupees 89 lakh had been received by the bank. So, however, due to the interim order dated 12/8/21 passed in this case, the auction had not been finalized. This court, in its order dated 16/8/2021, thereafter held that in the above circumstances, it would not be proper for this court to interfere in the matter. The writ petition filed by the petitioner was accordingly dismissed. The above being said, the petitioner is also an accused in a criminal case arising out of Dispur PS case number 869 of 2021. And he has been released on bail by order dated 17/11/2021 by this court. No, by this court in bail application number T024/2020. It's not just dispute, this is Paltan Bazaar. This is a Paltan Bazaar. And out here, he's saying, you've got two cases over.
My lord, bail application, my lord, only one is annexed, my lord.
Bail application, one is, but have you got two criminal cases against you?
My lord, I have received the brief today morning. I have to, not sure.
And what have I said this week? Full stop. He is also an accused in Paltan Bazaar PS case number 869 of 2020. Acha, it will not be Dispur, it will be Paltan Bazaar. Make it Paltan Bazaar, huh? Paltan Bazar PS 869/2020 under section 420/468, I think. Oh, no. Yes, he's got two cases. He is trying to be very smart. Huh? He's giving different numbers. He's 3298. I would say he's putting it as 869. 869 is actually Paltan Bazar. Just right. What is it? Without changing it, just say what is it? No, that will be Dispur case number 3298/2021. No, full stop. The petitioner is also an accused in Paltan Bazar PS case number 869/2021. Under section 420/468, I think. The petitioner was also granted bail in connection with Paltan Bazar PS case number 869/2021. While order dated 17/11/2021, passed in bail application number 3024 of 2021. So, sir, as per the allegation of the Chief General Manager of the APDCL, the accused had been arrested on the allegation of forging the signature of the Chief Minister of the time. Brave, sir. Very brave. And in another, that's all. You can do whatever. Right, sir. Good. Very fair. Right. Okay, it won't take time. And, I gave dictation to who? I gave dictation of here. I
So
don't
far
remember now what I was doing. There were some judgments that you all had given, no? No. Acha. Arey, that we get confused, now that's what I've got too many. Okay. No, I guess.
The weapon is seized, Lordship,
Huh?
is exhibited.
it is exhibited as
Now,
three.
Seized.
exhibit
Three.
three.
PW9 has give evidence to that. effect.
Okay, so,
One
Basic-
thing, my lord,
huh?
one thing, page
Yes.
52, my lord, of the paper book,
Yeah.
where this question was put to him that you do have anything to say in connection with the case? Answer is, my lord, 313 statement, my lord. For Russian Ali quarreled with Sophia demanding land and property belonging to her mother, and he and other killed Sophia Khatun. I was not involved in the incident. And that is being, my lord, reflected in Lordship C page 17 PW4, my lord. in cross, page 17.
One
cross
seven.
17.
17.
17, madam. In the witness called Noor Hussain, my lord. It start from 16. In cross, my lord, from last two lines, my lord. There was dispute among Dilbar Prashant and Sabura's mother over landed properties.
Prashant and Safura are
Yes, that
Right.
otherwise,
And
that
it
line
is
is
not the
also
fact that
Dilbar-
Dilbar-
But so it is mentioned, and he happens to be one of the independent witnesses, my lord. Others are the state brothers, 1 and 3.
then why did you surrender before the police?
That answer is not there. Ma'am. In spite of my effort, I could not bring it.
Okay, right. She also submits that in his examination under section 313 CRP, the appellant had given an explanation to the last question to the effect that
Yes,
the informant, Prashant Ali is the informant.
No,
Prashant,
Lordship.
yes,
Also, personality is informant.
Informant.
Informant. Lordship.
Is to the effect that the informant not a PW.
He is Lordship.
Yes.
PW1.
PW1, my lord. 18.
That is Pasan Ali.
Prashant Ali say,
Oh, the spelling is different. The informant, uh, who is PW1, and also the step brother of the deceased, had killed the deceased as there was a property dispute. As they were both claiming the property of their mother.
man,
So the key submits that the fact of the informant and the deceased having a dispute with regard to property is also reflected in the cross-examination, in the evidence of PW 4 during cross-examination, wherein he has stated
last 3 lines.
as
From
follows.
From bottom, third line, my lord. There was dispute.
There was dispute among Dilbar, Pashan and Sabura's mother over landed property. So they are fighting over whose property? The mother's property.
Mothers are different, fathers is same, my lord. Sabura is staying with her mother, my lord.
Okay. So they're not fighting over the mother's property.
It's
They're fighting over whose property? Belong to her mother. That's what the translation is correctly typical.
translation, my lord.
Because the mothers are different.
Mothers are
Mothers are
Mother is-
different.
That's right. The apparent process of first the learned abacus theory further submit that the mothers of the informant and the deceased are different, while they share the same father. P1. Last bit. What is it? No, not description. What they're saying out there, Russian Ali quarreled with Sakura. That is the he demanding land and property belonging to her mother. Without the father.
There is one question, Lordship, in
Okay, but that's all. Same, please. Okay, that's all, na? The Lieutenant counsel that submit that the federal sanction evidence does not form a complete case for conviction of the offender. By the law.
He is been behind the
Huh?
bar, he is behind the bar from date of.
According according to the
it is
instrument that
convenient.
certificate. Miss A. Pena, the learned. If it submit that the appellant had surrendered himself before the police station, immediately after the incident, along with the weapon that he used for cutting her up. He submits that though the now had not been sent for forensic examination, in as much as the same had been exhibited. No, in as much as there was no blood stain on the gun, or the said weapon had been exhibited during trial. As material exhibit number.
Exhibit 3,
material exhibit.
3,
Is there material?
material.
And what else?
Lordship, there are discrepancy in her 313 also, Lordship. In one question, Lordship, they have not marked the question. According to, I have marked it 21, while adducing 21 point, while adducing 44. Evidence, PW3, Dilbar Sheikh alleged that you are Safura Khatun's husband. What do you have to say? Answer, it is false. She was lying on the ground with the blood. It is false. She have taken to hospital. It is false.
He also submit that there is no evidence to show that the appellant was not in the place of occurrence on the night of the murder. And in the absence of any explanation by the appellant with regard to the cause of death of the deceased under section 106 of the Evidence Act, the same would amount to another link in the circumstantial evidence pointing towards the guilt of the. Anything else? That's all.
There is no more evidence to show, Lordship, that he was not there. Any suggestion from them that you have not
Okay.
done that?
Hearing concluded. Judgment.
Public.
What are the two more matters? Just come on, let's talk. Okay. What is the matter next? 14. What is 14? 302.
302, Lordship.
I will adjourn. No time.
Anyway, any day, point it is possible before the vacation. He's 70 years old, suffering inside the jail, man.
70 years suffering inside the jail. And if we uphold,
He'll die inside. What to do? Before vacation, if possible, I pray
Two
only for.
cross cases, one more cross cases is there. From the complainant side also, deceased is there. And from the
okay, sir, property dispute or something like that.
No, our man has been
Cow
killed.
have
Cow.
seed, Lordship.
Nothing was.
Eyewitness is there.
Eyewitness is not there. They are all family people.
Anyway, at least.
Before vacation, any day before vacation.
We are packed, Mr. Counselor. How can we pass?
No. I
And now
I
we
don't
have
pressurize your
two
lordship.
judgments.
But I only pray. I only pray.
22nd January.
January.
Message a lot. But it's a date lot because not time is not available. Math appeal also.
Sir,